Brown. I'm the founding managing partner of Brown, Dutton & Kreider Law Firm in Marietta, Georgia. I'm going to be talking about Georgia law, but I'm going to be asking our expert and our guest today, Chris Fanning, on Oregon law. So Chris, introduce yourself.
My name's Chris Fanning. I'm a divorce and family law attorney in Hillsboro, Oregon, Hillsboro is just outside of Portland. If you've seen, if you know anything about Nike, we're, stone's throw from the Nike campus. I drive by it every day kind of thing. I am becoming the managing partner, I guess, of our law firm. As the founding attorney is retiring this year, so it's kind of, we're going through that transition phase, but I'm moving up the ladder, I guess you'd say.
Awesome. Well, yeah, you're in your car and transporting kids back and forth, and we have no air conditioner in our office today, and we're in Georgia, so it's freaking hot in here. So I'm like, threw my hair up and it's sweating, but we're gonna make it through this. So my first question is, let's talk about children out of wedlock. Sure. So mom and dad have a baby. They are not married. In Oregon, what rights, if any, does the father have?
They have I would say the same rights as the mom is the simple answer, right? It's a little more nuanced depending on the circumstances. You know, if dad is not on the birth certificate, that changes the dynamic of the case. But generally in Oregon, you know, there are statutes that say when it comes to custody, there's no preference given to mom or dad simply because they are mom or dad. And when it comes to parenting time, some people interpret it as saying that the state wants there to always be a 50-50 plan. That's not really true, but the law is basically that we want kids to have as much access to both parents as possible, and as long as it's safe. Okay.
So here in Georgia, when a child's born out of wedlock, the dad has no rights, nothing, until he files a legitimation in the court. And so he has no legal rights, no physical rights. The only right that's established here in Georgia by signing a birth certificate is the right for the mom to go and put him on child support. So in Oregon, how would it work if, let's say, a mom and a dad have a child and the mom is keeping the child from the dad? How would he be able to establish a schedule or a parenting time? How would that work?
Well, he'd need to go into court and file a depending, you know, again, like if he's not on the birth certificate, he would have to do it you'd have to start by establishing paternity.
Sure.
And then part of that you can ask for custody, but to establish parenting time, you know, you kind of just do it as a petition to establish custody and parenting time. And if he's on the birth certificate, he doesn't have to worry about establishing paternity. He just goes straight to, I want to establish custody, parenting time. And with that, they'll establish child support and all the other things that they have to deal with.
So by virtue of just the facts, the mom usually has the child because she physically had the child. So if the parties are separated, then she would usually have the child more often. And if the parties are working together to have time, then it's not an issue. But if mom's keeping the child, then dad would need to file an action and seek a parenting plan where he has some established time.
Yeah, exactly.
Okay. If the father doesn't take action, so if, for example, let's say he's not on the birth certificate and the child is 6 or 7, is there a time period where if he doesn't take action that the court can say you don't get any rights to this child?
No, not really. I mean, you can always kind of, well, always, but you know, within 18 years, you can come back and say, well, you know, I want to have custody and parenting time and all these things. You know, the likelihood of success will diminish as the years go on. So they always have the right to do it. You know, I've had cases where dad's been absent for 10, 11, 12 years and then shows up and is like, I want to have parenting time, and courts will work out some kind of parenting plan. And usually in those situations, it's like, all right, first you have to jump through a lot of hoops to get to that point. But so the longer you wait, the more hoops you're going to have to jump through.
And let's see if you're serious and you're going to be here actually for the child, not come in and then bolt again. What about back child support? So let's say that a dad wants to be involved with his child and they weren't together, and at 3 or 4 he decides he's going to file a paternity action and he wants parenting time. Does he then have to worry about child support for those 3 years that he didn't support the child?
Well, so if paternity was never established, then actually yes. If you're starting from scratch, your name wasn't on the birth certificate, assuming they're not married, so you don't have paternity established. The way the law is written is, you could actually owe prenatal costs, and you could owe child support from the time the child was born up until now. Now, there's also laws that talk about latches and, not trying to bury somebody in debt for something, I had a case where it was like, this guy, paternity wasn't established for like 15, 16 years.
Yeah.
And the court wasn't, we're not going to make him pay 15 years of
child support, right?
Yeah. But we resolved that one. I don't know what the court would have ended up doing, but, he probably would have ended up owing some amount of past due child support for sure.
Yeah, that's interesting. So here in Georgia, we have you can ask for past due expenses. So you can go back and talk about like prenatal expenses and, childcare expenses, if they have diapers or clothes or whatever, but our law doesn't allow for actual back support. And so there's some detail in our case law that talks about back expenses, and that's not back child support because it's back reimbursements. But it's interesting to hear the differences from state to state, and it could ultimately cost you a lot. I mean, if you're looking at back child support for 5, 6, 7, 10 years, that's a big amount of money.
Yeah, I mean, I have one right now because our child support is also tied to parenting time. So if you don't have a lot of overnights, you owe, the fewer overnights you have, the more you owe. And so I have a case right now where it's like, the kid's, 6, 7 months old, he's going to owe all of these prenatal costs. And on top of that, he's going to owe child support. And, we're already talking $10,000, $15,000 plus of expense. And the kid is not even a year old. So
yeah, it's crazy. Mm-hmm. The amount of expenses. So in Georgia, we don't have our statute is the same or similar. It says there's no preference for either parent. But we do not have a statute that says that there is any default of custody to 50-50, and then the judge has to go from that default. Mm-hmm. Does Oregon have a default custody arrangement, and then the judge goes from there, or is it best interest standard? What is the standard in Oregon?
Yeah, so it's kind of a mix of all of them. I mean, the law is you have to do what's in the best interest of the child, right? And so that gives the court a lot of gray area. But there's also a statute that a lot of people point to saying, oh, this means you have to give 50-50. But what it actually says is if one party requests a 50-50 parenting plan, then the court has to give a reason why they don't think it's appropriate if they don't award a 50-50 parenting plan. And, usually they have some kind of justification, and the way, the appeals work out here, they don't have to have like some there was drug use or this, that, or the other. They just have to have some kind of reason like, oh, I think it's too far for the kid to have to drive to school or something like that.
Yeah.
And then there's, I forgot what I was going to say. I had another thought, but.
So in general, do the judges prefer 50-50 in Oregon, would you say? Or do you think that's not the most normal parenting plan that you see or the judges prefer?
I think that's the goal for a lot of judges. I mean, it is kind of judge specific, but I feel like most judges are kind of, angling towards that more as we go. I've had judges say that, they used to think that, well, the non-custodial parent gets like every other weekend, and maybe they take the kid out for dinner on Tuesdays, and that was kind of the standard thing. And the literature, like the psychology coming out of it, was like, well, this makes that parent more like an uncle or a grandparent or something. So that's what judges have been pushing more towards a 50-50 parenting plan. And I remember what I was going to say, which is counties are very different out here, like from county to county. Each county kind of does things a little bit different. Like Washington County, where I work, it's best interest, and you kind of know what the judges are going to do based on things they've done in the past. And generally, they are trying to make sure kids have as much access to both parents. And so 50-50 is, I wouldn't say it's the norm, but it's a goal that a lot of them will work towards. But then there's other counties where they have actual written, okay, the kid is this many years old, therefore we think this is the plan that it should be spelled out. So, like infant to 1 year old is like dad gets, his standard plan that they will just kind of default to is dad gets, 3 hours on the weekend, right? Like every other
Yeah.
weekend or something like that. So some counties will follow that. I don't want to say religiously, although, really closely. And other counties are just like, we don't have anything like that. And we just kind of make it up as we go. Not that they're just pulling it out
Yeah.
of thin air. They kind of similar things.
Yeah. And we're kind of similar. I mean, you could be in one county and you go to two different judges and get a very different, result. But it's interesting because something that's really important for the judges typically here is when somebody asks for a 50-50, they look at the history and they look at, okay, well, who has historically been the primary caregiver for this child? And if people have fallen in a traditional role of like a stay-at-home parent and then somebody who's, for example, traveling for work, then in our courts, it's very unlikely that that's going to result in a 50-50 post separation. But the court will consider, and they'll look at all the factors, but it's not the norm here. People are doing it, but it's not the starting point for judges.
Sure. Yeah. I would say it's not really the starting point out here either. And they always kind of start with like, well, what's been going on? Mm-hmm. But it's kind of geared toward, can we get this kid more time with both parents or even it out a little bit?
Yeah.
It's always so fact specific because, I mean, I had one case where I thought the dad works, the kid was like 3, the dad works overnights, then sleeps during the day. And he's like, I want a 50-50 parenting plan. I'm like, how are you going to do that with a 3-year-old? You're asleep all day and then you're working all night. This isn't going to work. And the judge is like, he'll figure it out. 2 months later, I came back and the dad worked early, but not overnight. And the same judge was like, oh, well, no, that's too much for, kids that were the same age to have that same plan. I'm like, what happened to he'll figure it out?
Yeah.
This guy wants to figure it out. That guy didn't care about figuring it out.
Exactly.
So it's very odd, but
yeah,
we do the best we
it's
can.
Definitely not black and white.
No.
And it seems to be the case, around the country as well. In your experience, what should someone do to better their chances of getting custody? So if they want primary physical custody or even 50-50, and maybe that hasn't been their norm, what would you suggest they do?
Well, so in Oregon, and I mean, I usually think of custody as separate from parenting time. So, legal custody, that, it is difficult because the biggest question there is who's been the primary parent. And that may be really difficult to overcome, even if you've been a really involved dad and all these things. But when it comes to parenting time, even if you don't have legal custody of your child, you can still have, theoretically, you could have more parenting time than the other parent. It just usually doesn't work out that way. But to better your chance to get as much parenting time, more, as much time face-to-face with your kid as possible, my biggest piece of advice is to show up, be a dad, and if it's the mom, be a mom, that will go a lot further than any of these other kind of things that I've heard about or gimmicks or trying to, tear the other person down. I'm much more interested, and judges seem to appreciate this idea of build yourself up, don't tear the other person down. And, I've seen it firsthand where, parents, I had a case where the mom was like living in a van with a cat and her boyfriend who would post videos on the internet of him smoking pot and stuff like this. And I was like, this guy, look at what's going on here. And she came in and was like, I realize I've done wrong and I haven't done these things right. And I need to clean up my life and I'm going to do all these things. And they're like, okay, good. You're looking at improving yourself. We'll give you, a little carrot to nibble on. And if she had come back and actually followed through on those, I'm sure she would have gotten a lot more parenting time. So yeah. I always start with build yourself up, be available. If I'm talking to dads, dad to dad, I say to them, I'm like, look, the easiest way to get more time and to make this work is to get along with the kid's mom and do things that are going to help her and support her and make her want you to spend more time with the kids, not turn this into some kind of battle. And it doesn't always work, but if you've done the work to try to make it easier on her, that's all stuff you can present in court, and then the judge will be like, well, why won't you give him more parenting time? Look at all these wonderful things he's done for you and the kids. So
yeah, I agree. And I think that you have to remember too, like, you're not required to stoop to someone else's level. And
yeah.
so if you're dealing with someone who's really difficult on the other side, you don't have to match their energy and their attitude and their actions. And kids see that you don't actually do that, that you're not the one talking about the other parent bad. And the judges are going to see that too. And so I always tell people too, like, you don't have to respond to every single message and every single allegation. If it's not about your kids and what's best for your kids and seeing your kids, then let it go. And all you have to do is keep trying to be involved. And if they're continuing to keep that door closed, then do something where you can lay out, look, here's these messages I've sent, here's these emails I've sent, that I've been trying to build this relationship, and keep it simply about the kids, not who did what in your relationship and why you're upset. So
yeah, I mean, I think that's just situations where you do have to kind of bring those things up, but it feels like such a waste of time. I had this case that went on for like 2 years, and the dad the whole time had all these negative, horrible things to say about the mom. And he started out with a 50-50 parenting plan. And he would accuse her of everything under the sun. And, she tried to poison me, and she did this and she did that. And she was like, what are we going to do about this? I'm like, well, did you do any of it? Well, no. Let's not worry about it then. And I'm not going to go back and say, well, he did this, he did that. And she was a great mom to begin with, but went and did some parenting classes, did some work with a therapist. And then when she went in front of the judge, we were just like, look at what a great mom she is. She's done all these things. And even after being a great mom, she keeps doing things to be a great mom. And dad got up and he was like, well, you should know that she tried to have me murdered. And the judge was like, I don't care about any of that. It wasn't true,
right.
But on top of that, like, and the judge is saying, well, what is your role for your son? Like, what is your job as a parent? And he's like, I taught him multiplication and division. He's like, but no, like, what is your function as a parent? And he couldn't answer it because he'd spent so much time just trying to say what a bad person she was. And
he devoted so much energy to that and forgot that the role was that the full focus on is what's best for this child and how can we move forward and raise this child to ultimately be a productive citizen.
Yeah, and he lost parenting time because of it. So
yeah, and it does. There's consequences to that behavior. All right, so let's shift. I've got a few questions about divorce before we get off.
Sure.
In Oregon, do you have fault-based divorce? And if so, how does that affect the outcome of a divorce?
We are a no-fault state, so it just doesn't really matter what happened during the marriage on a lot of the things. I had a case where I wish I could have given this woman the sun, the moon, and the stars for what she went through, and we had to go to trial, and she finally heard it from the judge and say, I can't make up for that. So it's a no-fault state.
Can the judge consider, so here in Georgia, we've got 13 grounds for divorce. Usually it's irretrievably broken. But, we do have adultery, we have habitual drunkenness, we have cruel treatment. There's 13 different grounds. And so what the judge do is they can number one, grant the divorce on those grounds, which is public record, and it can say why they were divorced. But also the judge can consider that in equitable division. So the judge can say, okay, well, because husband had an affair, and typically the judges don't do this unless it's related to money. So let's say husband had an affair and he spent 50 grand on his girlfriend. Then the judge can make that up in the division and say, okay, well, I'm going to repay you this amount, and I'm not going to do a 50-50 division because of his behavior. Can Oregon judges do something similar, or do they typically not?
They can. It's our standard is when we're dividing assets is what's just and equitable, which is a very gray area.
Yes.
We usually describe it as dividing everything in half. They're dividing the marital portion in half. But it gives the judges a lot of discretion, and judges are human. A lot of them do not want to hear, details of who cheated on who, or who did more of the housework, or any of that kind of stuff. But there are situations, like the example you gave, if husband goes out and blows all his money on, his new mistress or whatever, that's something that a court will look at and be like, well, she didn't really get any benefit from that, so
Right.
we're going to put all of that on your side, and you owe her money for it, basically. They may not come out and specifically say it that way, but I have had at least one judge where that was, a majority of the case, where I was saying, look at all this money he blew on all these different things. And she said, well, you've been a bad boy. And then.
And it's going to cost you now.
Yeah. I mean, she didn't specifically say, I'm giving her X amount of dollars more because of this. She just kind of said, you've been a bad boy, and then gave a division that was more favorable to her. So.
Okay. And the last question I have is about relocation. So what happens, let's say that, somebody's divorced in Oregon, or maybe it was a paternity action. It resulted in a parenting plan where they've got an order that is for custody and parenting time. What if one party wants to relocate from, do they have to get permission, or do they have to give notice, and then that can trigger a modification? How does that work?
Yeah, so every parenting plan by law has to say, neither parent can move more than 60 miles without giving the other party notice. So the way it works is you have to give the other party notice that you intend to move. If it's me and I'm trying to get somebody to move, I usually file that with the court. But it doesn't say you have to file anything with the court. You just kind of have to, in writing at least, let the other person know that you're planning to move more than 60 miles away. And then that will trigger it'll trigger the other parent, if they're on top of it, to file a modification case to try to stop the move.
Yeah, so that's similar to us as well. So what I've learned in talking to other attorneys from other states is in other states, you have to actually seek permission to relocate from the state with the child, but Georgia is the same. So if you're going to move, then our statute says 90 days, but a lot of people put, if it's out of state, it's going to be, a longer notice. But you have to give the other party notice of your intent to relocate. And then the burden is on the other party to say, hey, or I'm filing a modification for custody because I don't want my child to move to Oregon or to Texas or whatever, because then I can't do my parenting time because my child wouldn't live within a drivable distance. So the responsibility is on the other party. But sometimes I give the same advice as the attorney. If I have a client that's coming in and saying, hey, I want to relocate to Texas, then we also might take that step and say, okay, well, then your parenting plan is not going to work. So let's go ahead and file a modification based off that relocation.
Mm-hmm. Yeah. For me, it really just depends on the circumstances. I had the last relocation that really sticks out in my mind, the dad had just kind of disappeared. And I was like, well, you could just move, but it's safer to file the notice and send it to him. And he didn't care. And so then, after 60 days, she just moved. And we don't really have a time frame that you have to let them know. You just have to give them reasonable notice. And I would say I would push for 90 days if it were my client, but it's going to kind of depend on what the judge thinks of it. But yeah,
and our judges decide on best interest, right? So they're going to weigh, well, why are you moving, and does that outweigh the relationship that you're changing with the other parent because of the relocation? And they're going to have to look at both of those factors. So I always tell people, like, look, if you want to relocate simply because you found a boyfriend or girlfriend on your dating website, like, that's not a good reason to relocate if you're sharing a child in your state. So it's got to be more than that.
Yeah, it's similar in Oregon. Our law is actually that it has to be, because of the best interest, that you have to, the reason you're moving has to be because it's so beneficial to the child. It can't, we have people all the time, it's like, well, I got this great job offer. It's like, yeah, but how does that help your kid? That in a way that justifies removing the other parent from their life. So.
Right. Yeah. It's a pretty, the judges don't love to have a parent relocate, especially if the relocation is going to make it difficult to keep that other relationship established.
Yeah. That's how it is here too.
Well, it's always interesting Interesting to hear the laws of different states. I appreciate your time and your flexibility and coming
Yeah.
over here. But it was great to meet you. And obviously, if we can be of any help, you let me know. But I appreciate your time today.
Yeah, thank you. I appreciate you guys reaching out and having me.